Well, Sonia, if no one can hear me or see me, call me on my cell phone so I can get this adjusted. Otherwise, I'm just going to continue on through the presentation so that we can get your questions answered and get the content covered. So excited to talk to you this morning about an area of the law that isn't often discussed, and that is the area of joint employment doctrine. Often gets lost in connection with other more hot button issues, shall we say, things like sexual orientation discussions, gender discrimination, gender identity issues, and that sort of thing. Oftentimes see Thank you, Valerie, for the feedback on being able to see me and hear me. I appreciate that. I'm going to assume that's the case for everybody. We're going to talk about joint employment. It's an area of the law that really doesn't get a lot of play because it's not as, not as big of a hot button issue, like I mentioned, as some other things that get more attention. Yet, despite its kind of lackluster standard or status in terms of attention it gets, it's very important for employers in general and for Ohio providers in particular. And the reason is because okay, let's see if I can advance the slides now. There we go. So some of you may have heard me talk about this issue a year or a year and a half ago or so in a separate standalone session that Opera asked me to do on the Seneca Riyadh case. And it's an important topic because for providers in Ohio who are operating sheltered workshops or otherwise have relationships with other employers in the community where they are placing individuals with disabilities for employment opportunities, these concepts are going to come up. And they are concepts that you want to think about at the outset of a relationship of the type I've described in advance of when you get into the relationship. As you might recall, those of you that saw the Seneca Riyadh presentation that I did a year and a half or so ago, the fact pattern in that case was three individuals with disabilities suing a provider, the provider's customer, who is taking the product from the sheltered workshop, as well as the county board, MRDD board, alleging that all three of those entities were joint employers of one of the three individual plaintiffs in the case. Now, I just thought I'd stop here. Let me see if I did the polls correctly. See if we can push one of these polls out. Going to ask you to tell me, does your agency operate a sheltered workshop? Just pick yes or no, and then we'll see how the results come in here. All right. So we've got about a third of the folks do, about a third don't. It looks like some results are still coming in. Let me launch another poll here because it's not just this area that it arises in, but it can also arise in other areas. Does your agency, let me launch this one, do you as an agency seek out other employers with which to partner in the community for placement of consumers with employment opportunities? So let's go ahead and click yes or no there, and let's see how that runs. All right, about almost interestingly, almost a mirror opposite of the sheltered workshop question. And then let's do one more here, since it looks like I'm doing this part right, notwithstanding my stumble out of the gate on this platform. Let's try this question. Do you use temporary agencies or subcontractors to accomplish the work of your agency? Oh, wow, interesting. Almost a much stronger no response there than I was thinking would be the case. Well, so that's very interesting. So we've got the majority of people here doing partnerships with other employers in the community to place individuals with disabilities. We have a minority of attendees who are operating sheltered workshops, and we have a decided minority that might use a temporary agency or a subcontractor to get work done. So this is interesting because really what we see here, I think, is see if I can figure out how to get back to my other screen. All right, there we go. So what this means, I think what the poll results tell me is that while a lot of you are not going to be presented with the factual pattern that's present in the Seneca Riyadh case, some of you might be, most likely what the issue is going to be is looking at these employment relationships, looking at these placement relationships to address potential risks both for your agency as well as for your partner in the employment relationship and how those are set up. So we're going to do that today by looking in these basically three areas, and then for those 20 or so percent of you, 25% of you that would have a particular interest in the Seneca Riyadh case, we will talk about a little bit of update there that might be of interest to you folks. We're going to start out with some level set. We're going to define the term. What do we mean by joint employment? We're going to then shift into the question of what are the standards that courts and agencies use to establish whether a joint employment relationship exists. And then we're going to finish, again, before we touch on the Seneca Riyadh case, we're going to finish with some best practices, some proactive steps that you can take when you're addressing this issue. All right. So, still fumbling with the advancement of the slides. There we go. All right. So, what is joint employment? Joint employment is the principle that an individual worker can have multiple employers, all of which are potentially responsible for ensuring compliance with relevant labor laws. An employee always has to have at least one employer, but they can also have more than one employer, depending on the situation. And how one determines if there is a joint employment relationship really depends on the reasons one is asking. As the outline suggested on the prior slide, the test is going to be different depending on what compliance reason you're asking for. And so today what we're going to cover is probably the three most frequent. We're going to cover the test that courts apply in equal employment opportunity cases like discrimination, harassment, retaliation. We're going to talk about the NLRB's test that is applicable when it comes to issues of traditional labor law. So if your partnering employers are unionized, this could be an issue. If your agency is unionized, this could be an issue. If you and the employer with whom you're partnering both don't want to have a unionized workforce, this could be an issue. And then finally, we're going to finish off on Department of Labor's joint employer standard, given the potential liabilities around wage hour issues, particularly if your agency might be using subminimum wage certificate or something like that, could magnify or add other areas of possible wage hour exposure in this area. We're going to focus today on the similarities between these tests, if possible, and to the extent that we can, but know that the details in some of these tests are different and can end up with different outcomes on similar fact patterns in different substantive areas of the law. So, what types of relationships can give rise to a joint employer finding? I kind of let the cat out of the bag early on the polls on this one. They really kind of capture where the joint employer relationships can exist. The primary employer and the staffing agency, the contractor and the subcontractor, franchisor, franchisee. That's obviously not an issue, I don't think, for anyone here. Although maybe in some of your partner employers it might be. If they're a franchisee of a larger operation, they might have these concerns themselves, but they would not obviously come into play between your agency and the partner employer. And then lastly, the service provider, such as all of you folks, and the community employer of individuals with disabilities. These are all a number of scenarios where these joint employment area issues can come into play. And as I noted in my quick reminder on what the Seneca Riyadh case deals with, could also come into play vis-a-vis county boards. So if any of our participants today are employees of county boards, this is not necessarily something that you escape simply by being the county board. So what does it mean to be a joint employer, and why does it matter? Well, just like the direct employer can be held responsible for employment violations and employment compliance issues, a joint employer can have similar liabilities. And so, for example, in the unionized space or in the National Labor Relations Act space, you could be jointly liable for each other's unfair labor practices. You could be jointly and severally liable for wage hour violations under the Fair Labor Standards Act or under the various equal employment opportunity statutes such as Title VII, ADA, and the FMLA as well gets in on the act. The FMLA, by the way, will follow most often the FLSA's standards for joint employment. You could even be, if you are currently unionized or your partner employees are unionized, that your individuals with disabilities are working with or side by side, you could also end up with bargaining obligations between you and your own union, or you and the union that represents your partner employer's employees. So I think I've kind of covered this maybe a little out of order, and I think I've already made the point that you always have at least one employer. And the point here is figuring out if you have more than one employer and allocating the legal liabilities accordingly. So let's start. Like I said, I'm going to hit three major areas. I'm going to hit the test that the courts and the EEOC follow in EEO law. I'm going to hit the NLRA test for the test that's applicable for issues related to unionization. And finally, I'm going to hit the Department of Labor's test for purposes of wage hour exposure. On the court side, the federal courts in the Sixth Circuit use multiple factors to determine whether an entity is a joint employer. And for those non-lawyers in attendance, the Sixth Circuit is the federal court of appeals that has jurisdiction over, significantly for our purposes, Ohio, but also that state up north, Kentucky, and Tennessee. If you have operations, I know this is very infrequent, but to the extent that you might have operations in other states, besides those, different rules may be applicable, but again, they're going to have the same core similarities, and the significance of the issues will be the same. The purpose of the joint employer inquiry in the courts is to explore whether one entity has the ability to exert significant enough control over the employees of another entity. No one factor is going to be dispositive. Now, some factors might be more important than others, might be more equal than others, but none is going to be dispositive by itself in order to find joint employer status. And in fact, not all the factors need to be present in any one case in order to be deemed a joint employer. I was going to cover this a little bit later, but I think I'll do it now because it's the first time I've said a word that you're going to hear quite frequently. And I think it's a helpful way to remember what the standard resolves to in a single word, and that word is control there in the middle of the page. And so, in a way, this is obviously going to date me if the video picture of myself hasn't already dated me, but you could, if you wanted to, I suppose, call this the Janet Jackson test. Of course, my reference there is to her mid-'80s breakout hit Control from the album of the same name. And I was actually listening to the song a little bit just before the presentation began because I think it really does kind of encapsulate what the test aims to look at. which entity has control over the employee and how much control is there in particular significant regards. So there you have it. Joint employment law in a nutshell by Nelson. It's the Janet Jackson test. So branching out from that, we see some of the factors here on this slide that the courts will consider. They'll look at the authority to hire and fire and discipline. They'll look at promulgation of work rules and conditions of employment, who controls compensation, who supervises day-to-day activities, what type of interrelationship is there between the operations of companies. Do the companies have common management or ownership? Who controls labor relations? And by the way, labor relations, for those HR professionals in attendance, you might think of that as the sub-discipline. That's different than HR. It's a sub-discipline of HR. What the courts mean by labor relations is basically HR. They just use that more unique term of art for the descriptions of what they're looking at. So in the sixth set, so that's the range of factors. And like I said a couple minutes ago, these tests have this test has a multi-factor type of analysis in the federal courts for discrimination purposes. But if you look over time and you look at what is the most frequently cited factors and which ones tend to be highlighted by the courts as more important than others, what you learn is that it resolves kind of three things. Number one, the authority to hire, fire, and discipline. Number two, the control over pay and benefits. And number three, supervision. And if you can manage the relationship in such a fashion that one party or the other minimizes their input into these three things, then it's most likely that there's not going to be a joint employer relationship that an employee could rely upon to say not only is the agency liable, but also the partner employer is liable too, or vice versa. It's advisable, I think, when you're looking at, so these things point out I think these things underline the point I made early on, which is this area, if you know about it and you address it in advance, is an area that you can take some proactive steps to ensure that you are not, and that your agency and the partner employer are not kind of stepping in a pile of stuff you don't want to step in and staying out of this sticky wicket that joint employment can become by addressing up front and thinking about how the relationship is going to be structured between you and the other employer to address these types of issues. That's why, for example, I know there's it looks like we settled on about 16% of the folks here today are actually using temporary agency employers, but it's why if you have a relationship with a temp agency, and you should have a written contract with that agency, and that contract should address these joint employment issues and potentially include some indemnification language between the two employers that lines up with how this liability is going to be parsed out in the event that one of those temp agency workers were to sue both your agency and their temp agency in the same lawsuit. All right, so that's the court test. Let's shift focus to the NLRB test. Again, I'd echo Sonia's comments. If you have any questions, please feel free to post them in the chat box. I think I've figured out the platform now, so I do think I'm able to see those as they come up, and I'm happy to take those questions as they come up. Alternatively, I believe I'm going to have at least a few minutes at the end to take questions in that fashion as well. Okay, so the NLRB test. The NLRB test is an evolving one, and it's heavily influenced by politics and which party controls the White House. That's the way it's always been. That's the way it's always going to be. I'm not trying to be political here with less than a week out in the election, but that's just kind of the way it is. Now, the swings have become more accentuated over the last couple of administrations. There always used to be some, if you think about it as a pendulum on a grandfather clock, there always used to be some swings back and forth between Republican and Democrat-controlled NLRBs. those swings have become much more pronounced over time, in my view anyway, between what a Democrat majority board will hold and what a Republican majority board will hold. And as you see on the slide, using President Obama and President Trump as examples, the Obama board was less employer friendly and the Trump board has been more employer friendly. That's just the way it's kind of always been. The current NLRB standard on joint employment actually comes from the NLRB's final rule that was issued earlier this year. But to get to that rule, the board followed a relatively tortured path that began some number of years ago. And it began under the Obama board decision, with its decision in the Browning-Ferris Industries case in 2015. In that case, the Obama board, again, I indicated there was less employer friendly, set out a very employer unfriendly test as to when a joint employment relationship exists. And the Obama board held that existed where a company has indirect or even potential control over the workers that are directly employed by another company. And the concept that's key here is that potential for control or the indirect control, because that's where the BFI case, as it's referred to, the Browning-Ferris Industries case, really departed significantly from past precedent on how you establish joint employment relationships. So fast forward 2 years to 2017, the Trump board now has a Republican majority on it, 3-2. They take up and decide the Highbrand case. In the Highbrand case, it reversed BFI, focused on three elements. Number one, did the joint employers actually exercise joint control, not just merely have the potential to do so? Was that control direct and immediate, not removed in some fashion? And was that control limited and routine? Because if so, it didn't create a joint employer status. Now, after Highbrand was decided, there was some political drama, shall we say, about the decision. And ultimately what that led to is that the board vacated Highbrand in 2018 because it was determined that a board member had improperly failed to recuse himself from the case. Now I'll save you all the political nuance and intrigue and insider stuff on this, but suffice to say that the standard under which it was then decided that the board member should have recused himself was not without dispute. So anyway, what the board decides to do is, instead of making this rule by case adjudication, which is what the NLRB has historically done, the NLRB would issue a rule. They also have a rule-making authority, just like any other administrative agency might have. But they've not utilized it very frequently. The NLRB historically has been set up as an agency that decides and regulates its assigned area by case adjudication, just like a court would decide a discrimination case or whatever. NLRB is deciding unfair labor practice charge cases and setting forth the rules in the context of their holdings in these various cases. The Obama board started moving towards rulemaking more frequently, issuing some rules on elections and that sort of thing. And the Trump board decided to continue moving in that direction and has issued a number of rules that deal with not only procedural issues on how employers unionize, but also some of these substantive issues like when joint employment exists. So they proposed the rule way back in 2018. The comment period on the rule was extended multiple times and ran out over almost about a year and a half or so ago now. They considered 30,000 different public comments and finally published their final rule in February this year, as we all began focusing on the COVID virus. The date was effective April 27th, 2020. And what that rule does is it basically pulls back on the BFI holding and makes it harder for employees, workers to prove that they were jointly employed by two separate businesses. So under the final rule, the NLRB holds that to be a joint employer, a business must possess and exercise substantial, direct, and immediate control over one or more essential terms and conditions of employment. And you can see I've captured those on the slides for your future reference, but they're the kind of the horsemen that you would expect: wages, benefits, hours, core things that most employees are very interested in and concerned about when it comes to any kind of employment relationship. Significantly, the final rule says that a reserved right of control is not enough to prove a joint employment relationship. The right must actually be exercised. So, what are they talking about here? Here's a provision that I see often in temp agency provisions. Maybe it even exists in some of your partner employer agreements or understandings. And that is a provision that says if we don't like the job that Mary or Joe or whoever temp worker is doing, we can tell you, temp agency, don't send Joe or Mary back here anymore. That is the example of this reserved right that the BFI case was focused on, that some of the other cases focus on, and that the NLRB majority was, when it issued its rule, concerned did not trigger joint employment liability. But under the Obama board, clearly it did. That is the kind of reserved right that we're talking about. And that provision appeared in agreements quite frequently between contractors and subcontractors, between temp agencies and user employers. And like I said, might exist in some of your understandings and relationships with either your sheltered workshop customers or with your partner employers in the community. All right, so that is the NLRB test and kind of where it sits currently. It is in effect, and that is the test that is now being applied. We will see whether what happens in 6 days in the election, and if it becomes a Biden board, then ultimately the NLRB always has a majority there are members of the party that controls the White House. And so a Biden board will result later in 2021, when the current terms of board members run out, will result in a majority Democratic Party board. And I think we can assume that the pendulum will swing back toward the side of unions and employees and against employer interests in that situation. And conversely, if Trump wins next Tuesday or whenever the election gets decided, then we'll see, I think, more of what we've seen over the last 4 years, which is generally fairly employer-friendly rules. All right, so we've talked so far about the courts. We've talked about the NLRB. One last agency I want to talk about to discuss kind of what's happening here is the Department of Labor. Because it obviously regulates wage hour issues most prominently. These rules would also be used by the Department of Labor anyway in its enforcement of the FMLA to the extent you ever get a DOL investigation of an FMLA violation as opposed to a private party lawsuit. Even the lawsuits could potentially look to this rule for some guidance, although how much guidance we'll see here in about 5 or 10 minutes is up in the air right now as a result of a ruling by a federal judge in New York. So what's going on at the Department of Labor? Department of Labor is also in on this act. They also issued a final rule that interprets joint employer status under the FLSA. It published its rule on January 12th, and it was to have an effective date of March 16th, 2020. Here's what the Department of Labor rule distinguishes between. It distinguishes between two types of joint employer scenarios under the FLSA. One scenario is when an employer employs the employee to work, but another entity simultaneously benefits from that work. That is oftentimes called vertical joint employment. And then the second one is when one employer employs a worker for one set of hours in a work week, and another employer employs the same worker for a separate set of hours in the same work week. And that is often called horizontal joint employment. And the Department of Labor uses two different rules for these different tests. So let's talk about some examples here, just to provide maybe a little bit broader context and understanding, hopefully, of what we're talking about. Vertical employment, the classic example is the temp agency and user agency. So for those 18 or so, 10% or so of you all that use temp agencies, you are in a classic vertical joint employer potential relationship. So if you kind of diagram it out, if you were put it on a whiteboard, I didn't try to figure out how to use any function that this platform might have on a whiteboard for understandable reasons. You would have a joint employer above, you'd have the user employer below, and the employees are flowing from the temp agency down to the user. The temp agency is benefiting from that employment because they're charging a premium on the hourly rate. The user agency is benefiting from that employment as well because those temp workers are getting stuff done for the user agency. An example of horizontal employment might be let's say a construction company that builds houses, let's say, and a company that runs a HVAC repair business, let's say, or installation business. But it turns out that the construction company A and the repair business B are both owned by Mary, who saw an opportunity many years ago to branch out into other things and set up other employer entities to take advantage of those business opportunities. So Mary has both company A, excuse me, has both company A and company B that she owns, and she takes Jane, let's say, and works Jane 40 hours a week in company A, and then also works Jane 20 hours a week in company B. If A and B are joint employers, then Jane has 20 hours of overtime. If A and B are not joint employers, then Jane has no overtime. So that's kind of a way to think about and visualize these vertical and horizontal joint employment relationships. So what are the rules then, Nelson? Well, here are the rules. In the vertical employment relationship, the Department of Labor says, well, we're going to focus on the economic realities of the relationship to determine whether the worker is economically dependent on and thus employed by another entity involved with the work. Now, the Department of Labor says that, but then what they do in terms of the standard is that they say these economic realities are going to be determined by these four factors: who supervises the work being performed, who controls the employment conditions, who has the authority to hire and fire the worker, and who maintains the employee's employment records. What's important to understand about the Department of Labor rule is that this is far narrower of a test than some of the other tests and other factors that were considered by federal courts around the country to look at these economic realities of the work the worker is doing. So if you apply that in the context of a provider and a partner agency, you can see that it might be possible to manage the relationship in such a factor that those four factors would suggest no joint employment relationship. Whereas if you look at just from a generic or a general point of view, and you ask, well, what are the economic realities of this arrangement? Well, the economic reality of the arrangement might well be that without the partner employer, the worker the individual with disabilities would have no employment opportunity. And so you can kind of start to see how the factors are described and how they're listed is critical to determining what the economic realities are, and also therefore critical to as to the conclusion as to whether a joint employment relationship exists. On the horizontal side, the Department of Labor says that the focus is on whether the two employers are sufficiently associated with one another and therefore jointly employ the employee. So vertical looks at looks at what's happening with respect to the worker. Horizontal looks at what's happening with respect to the two agencies. And here, again, the most common scenario that we have amongst participants today is agency and partner employer in the community. Unless you have things like overlapping board members or some sort of overlapping management or something between your agency and a community employer of disabilities, and that may be the case. I mean, obviously, the first stop you might have in trying to find partners in the community would potentially be your board members who might run or have influence at employers in the community. So that's really the only risk you probably have. That'd be an example, I should say, of a risk that you might need to manage to avoid a horizontal joint employer finding. Here are a couple other slides that have examples in addition to the temp agency that I to Mary's construction and HVAC service company example that I gave you earlier on, just for takeaway purposes for y'all. All right, so what then is the DOL's rule? Well, DOL's rule says that, like the NLRB rule, we're only going to look at actual exercise of one or more of the four control factors. The reserved right alone is not going to establish a joint employment relationship. So, really simple, right? Well, unfortunately, I wouldn't have anything to talk about if it was that simple. So, this has been muddied up, unfortunately, as a result of a decision from a federal judge in New York State who last month issued a ruling that struck down and vacated the Department of Labor's final rule as it applied to vertical employment. It left standing its rule as it applies to horizontal employment. And that all arose because about a month or so after the DOL's final rule issued, several state attorneys general sued seeking an injunction against the Department of Labor, 17 states in particular, plus the District of Columbia. Ohio was not one of those parties that sued. As you can see from the slide, the New York federal judge agreed with the states that had brought the claim and vacated substantial portions of the rule, concluding that the Department of Labor's rule violated the Administrative Procedures Act. Again, I'm going to spare you the detail and minutia associated with all the administrative law principles at play here, but suffice it to say, from a 30 or maybe even 40,000 foot level, pursuant to the APA, agency rules can be set aside if they're arbitrary, capricious, abuse of discretion, or not otherwise in accordance with the law. Obviously here, the FLSA would be the law that was most significant. And the court found that, in fact, that's what the Department of Labor's final rule was as applied to vertical joint employment. It was arbitrary, capricious, and an abuse of discretion, as well as contrary to the law. And it held that in a number of different respects. Again, I decided not to delve into that minutia because I'm not sure it really is that important in terms of the impact of this development for all of you in the practical day-to-day. But suffice it to say, what the judge found is that the Department of Labor's test conflicted with the FLSA's provision, so it was inconsistent with law. And one of the examples of that, just for brief discussion purposes here, was that the definition of joint employment, that four-factor test, was too narrow and rested improperly on common law principles, not the statute. And it's been established for many, many years, the court said, and I think the court's right on this, that the FLSA is designed to go beyond what the common law would say is an employment relationship in order to accomplish the remedial purposes of fair wages for fair day's pay that is at the core of the FLSA. So the the Department of Labor can appeal this decision. But as of yesterday, no appeal had been filed. They have about another 2 weeks to file the appeal if they're going to file. And as of this morning, the Department of Labor, really hasn't said much on the website. If you go to the Department of Labor's website and you search joint employer regulation, you're going to find their kind of landing page that talks all about the announcement of the rule, the effective date of the rule, et cetera, but doesn't say anything about the New York court's decision. So, stay tuned here. It's unclear whether the Department of Labor is going to say, okay, yeah, we'll go back to the drawing board and try this again, or whether they're going to appeal. And that could turn in large part on what it looks like happens on next Tuesday. It also could simply be a function of the Department of Labor is a big bureaucracy, and it takes a while for them to decide what they're going to do about this kind of stuff. So in the meantime, though, I think for all of us, what I'd leave you with is the court did ultimately say that the vertical rules are vacated and struck them down as inconsistent. And so with that decision out there, I think that employers are well advised to not rely exclusively on the Department of Labor's regulatory test when structuring these situations if the goal of that employer is to avoid a joint employment relationship, because it's very well possible that they will be done away with, and certainly even if the case is appealed, if a Biden administration takes over in January, obviously they're going to have a very different view of this joint employer rule. In fact, here again, I didn't share all this detail on a slide, but one of the things this was a reaction to was that under the Obama Department of Labor, the Department of Labor issued what they called at the time an administrator interpretation that substantially broadened the joint employment standard and made it a lot easier for workers to assert that more than one employer was their employing entity and therefore liable for wage hour violations and that sort of thing. All right. So what does all this mean for your business? We're going to spend the next few minutes talking about some best practices and then finish up with a Seneca re-add. So number one, it means it's important to have qualified employment law counsel review your contracts with your third-party companies so that they address this issue. Who are the third parties? Your partner agencies, or partner employers in the community, your sheltered workshop customers, particularly if your sheltered workshop is co-located on your customer's property. That was the fact pattern in the Seneca re-add case, and I think, at least based on the allegations in the complaint, really kind of contributed to a fact pattern in which a joint employer argument could be made more readily than in a scenario where the sheltered workshop is on the agency's property and it has multiple customers that it might deliver products to. In any event, when you look at these contracts, you're going to have to look at a number of things. You're going to have to look at the Janet Jackson rule. You're going to have to look at who's got control over the employees and who doesn't. You're going to have to look at provisions about cooperation in the event of an agency investigation or litigation. You're going to want to look at the coordination of insurance coverage. I know a lot of providers have Cary employment practices liability insurance, EPLI coverage. You want to make sure that your policy is going to cover a joint employer situation and how it's going to cover a joint employer situation, or is it the other entity's EPLI policy, to the extent they have one, going to cover it? And again, as long as I mention EPLI, I always like to put in this plug as well. It is vitally important for an employer that has EPLI coverage to think about the choice of counsel provisions. A lot of insurers have panel counsel that you're obligated to provide to use in the event of a employment discrimination lawsuit. And if you have existing counsel relationship with an attorney, or you want to have a particular attorney handle your employment discrimination litigation because they're more familiar with the industry or they're more familiar with your agency, it is vitally important that prior to underwriting, prior to a new term going into effect for your coverage, you ensure that that firm or that lawyer is either on the panel that you're able to use, or you get a rider for your EPLI policy that permits you to use that particular attorney. Otherwise, you'll be required to use panel counsel who may or may not know anything about your industry and may or may not know anything about your agency. So I digress a little bit, but every time I mention EPLI, I think it's vitally important because I've seen dozens of cases over the years where this happens, and it's a surprise to the employer. Finally, the other thing you're going to want to look at in these in these contractual arrangements is primary and secondary liability. Who's first in line, who's second in line, what indemnification provisions there are about whose liability that's going to be, and so on. Another proactive step when you have these relationships is make sure you have an individual that's going to monitor these arrangements. That person should know what the division of control is and should kind of serve as a traffic cop, I guess, for lack of a better term, to make sure that each side stays within their lines of control. Because in the facts of these cases, they will not only look at if the Department of Labor test is overruled, for example, or ultimately reversed, they're going to look not only at what the contract says and what your potential for control is, what reserved rights you have to control, but both, whether it's a pro-employer rule or a pro-employee rule, both tests are going to look at what actually happens on a day-to-day basis. And so you might have the best drafted contract you could possibly have, but if in your implementation of that contract, the day-to-day is implemented in a way that's inconsistent with how the relationship was envisioned, your contract isn't going to mean anything. It's going to be what the actual day-to-day course of dealings, as it were between, with respect to the employees alleged to be jointly employed. Another thing to think about, and this is not, I'm not going to dwell on this long because it only affects a very small number of you. I mean, some employers would, and I guess maybe this would potentially affect your partner employers might be thinking about this. So I guess maybe it is important to think about. An employer who's interested in avoiding joint employment entanglements really needs to think about, should we outsource at all? Should we hire? Should we partner with another agency to provide, someone who could help with our custodial work or help with our assembly work or whatever the case might be? Because if we do, we're going to have this additional area of potential liability open up to us. And that's not something we're interested in doing. So, while you all as providers might not have this as a significant issue because not very many of you are using temp agencies or subcontractors to accomplish your work, your partner employers might be very well thinking exactly this, which is, do we really want to get into this potential morass of employment joint liability? And then finally, carefully select, I guess this is not finally, there's one more. Carefully select your business partners. Anytime you have joint employment, your fortune, shall we say, is going to be tied at least somewhat to how the other employer in this relationship acts and how they treat their employees. And so, just be careful and know going in with your eyes wide open, what you're getting into in that regard. And then finally, reassess your needs periodically. Once these relationships get in place, set up a recurring revisitation of them, preferably led or triggered by that person that's been charged with monitoring them, but bring the key operations people or HR people together or whoever the relevant actors might be, and say, is this still functioning how we think it's functioning? Is this still meeting everybody's needs? And so on, so that you can kind of address this on a going forward basis. All right. Excuse me. All right, so let's bring it home here with a brief Seneca Riyadh update. As you might remember, this case centers around the 3 claimed causes of action. Again, these are alleged causes of action. As I'll explain in just a minute, we still don't have a decision on any of these, so these are all just the plaintiff's allegations. And they're alleged against not only the provider, but also against the workshop's customer and the county board, as I mentioned earlier. They allege violation of the ADA's employment provisions. They allege violations of the Ohio Revised Code prohibitions on disability discrimination in employment. And finally, they allege violation of a provision in the Ohio Revised Code that prohibits what's called aiding and abetting employment discrimination. And that allegation is made only against the county board. It's not made against the other employer entities. So, as you might recall, this lawsuit has been stayed pending a completion of the Department of Labor's 14C subminimum wage proceedings, because at the same time, actually predating the filing of the disability discrimination lawsuit, making these joint employer allegations, there had been an ongoing administrative proceeding alleging that the three workers involved were not properly paid the subminimum wage because the provider failed to satisfy the 14C requirements to pay them the subminimum wage. Well, that's really the update here, is that proceeding has finally concluded and not in the provider's favor. On September 14th, 2020, the Department of Labor issued a decision and order in the 14C proceedings that held that Seneca Riyadh had violated the FLSA's minimum wage provision because it was not entitled to employ the 3 individuals who were at issue under the subminimum wage exceptions. And on October 13th, Seneca Riyadh filed a separate lawsuit in federal court to appeal that minimum wage decision and order. We think that it's likely that this will continue to stay the proceedings in the disability discrimination case, but we'll continue to monitor this case and report to you periodically as opera members what we learn about it. All right, look at that, 5 minutes for Q&A. I will open it up here for Q&A. I think, see here if I, all right, I don't think I have any questions yet, so please post any questions you might have in the chat function. I'd be happy to answer what I can. One question: would shared living contractors present any issues relevant to subjects we are discussing in this seminar? To the extent that you have employment relation, good question. I think that the answer to that, and really any kind of permutation of that question, comes back to the core question. The relationships that you want to look at are going to be those that have an employee of yours doing work for another company that could be alleged to be an employer of theirs as well. That's going to be the key focus, is anytime you have an employee going to another employer's job site, doing work. Anytime you have a person who's benefiting from the employment of the work of that employee, that's when you want to think about these joint employer rules. Go back to that slide. Final thing I'd say on that is go back to that slide that talks about benefiting from the work of the other, the DOL slide that talks about when a joint employment relationship is concerned about, when the DOL is concerned about a joint employment relationship. And that's when you want to think about these types of issues. Hopefully that answers that question. And I apologize, I see that came in about half an hour ago, so my apologies to the questioner on that one. I hadn't scrolled down far enough. Any other questions here before I wrap up in time for you all to get to the next session? Okay. Hearing none, I just want to say thank you all for your time today. There's my contact information. If anyone, I should say, if anyone is interested in the decision on the Seneca Riyadh case, 14C proceeding, certainly feel free to give me shoot me an email. There's my contact information, or give me a call. I'd be happy to provide a copy of that. If you had interest in that decision for reasons unrelated to joint employment considerations. With that, I'll stop talking. Sonia, if you're still there, maybe I'll turn off my camera, turn this back to you. And again, thank you all very, very much. Have a great fall, and I hope that 2020 ends positively for everyone. Bye-bye.